Okay, so I'm going to be talking about criminal justice and neuroscience. I think everyone else in this little group is going to be talking about the same topic or related topics. Every time I think about this topic, I come away extremely ambivalent. Sometimes I think neuroscience is going to change everything, and sometimes I think neuroscience is going to have absolutely no effect on criminal justice. And you can tell from the title today, for this morning, I may change tomorrow, but this morning I'm moving in the direction of the latter position. I think given current science and given current law, it's unlikely neuroscience will have much useful for the criminal justice system. Now, of course, there are a lot of other people who take a different point of view on this score. A lot of people are very excited about the so-called brain defense. The ABA Journal ran an article, a lead article on this just a couple of months ago. At the same time, most courts have been pretty reticent about accepting neuroscience evidence, and I think that's probably right, at least when we're talking about culpability issues, at least when we're talking about defendants trying to use neuroscience to get a defense at trial, to get mitigation at sentencing. Now, usually I bolster that statement and begin defending that statement by going through all the legal doctrines you see right here, the involuntary act doctrine, mens rea defenses, the insane defense, and mitigation law and capital and non-capital sentencing. But I'm not going to do that for three reasons. First of all, Hank, he's only given me 15 minutes, so I don't have time to do that. Secondly, most of you probably know this stuff already. Either you teach it or you can remember way back to your first year of criminal law and remember these doctrines. And thirdly, I've now given you 45 seconds to look at it, so I'm done. Okay? What I want to focus on are the types of neuroscience evidence that might be presented in court. And I want to focus on them in what I consider to be ascending order of usefulness, ascending order of usefulness. So the first kind of neuroscience research that's, or information that's presented in criminal trials, and probably the most common, is simply a picture of a defendant's brain showing some kind of neuroaberration, or maybe some kind of chemical imbalance evidence, or maybe evidence of an fMRI image that shows some kind of strange reaction to certain kinds of stimuli. This is a pretty common kind of evidence. It's totally useless, in my opinion, because it shows no connection between the neuroaberration, if I may call it that, and the crime. There has to be some kind of causative link, or it's really irrelevant to any kind of criminal justice issue. Now, the exception that proves the rule, and I actually don't know what that phrase means exactly, but this might actually be an instance of where the exception does more or less prove the rule. The famous Ort case. Many of you have heard of this case, right? This is the guy who committed sexual assault after sexual assault. Doctors finally investigated, found a large tumor in his brain, removed the tumor. He stopped assaulting people, but several months later he started doing it all over again. They once again investigated him. Sure enough, the tumor had grown back. They moved the tumor, and everything was okie dokie. Okay? The point I'm making, though, with the Ort case is this is an incredibly unusual case. You very rarely have this kind of evidence. Usually all defendants have is a picture of a brain scan which shows some kind of aberration. And that just doesn't cut the mustard with respect to useful neuroscience evidence, in my opinion. Now there's, well, actually, let me say one more thing about the Ort case, just while we're on it. Even in Ort's case, just to go back to the doctrinal issues that I had on the previous screen, it would be hard for him to get a defense. He intended his sexual assaults. He knew they were wrong. He tried to avoid detection. So the only kind of defense he might have at trial under current doctrine is the volitional version of the insane defense. And he probably wouldn't get that because most states don't even recognize it. And then what about sentencing? Well, if you're being sentenced in federal court, he probably wouldn't get any mitigation. Why? Because in federal court, no impairment, however significant, is relevant when you've committed a violent offense. And that's what he committed. So that kind of evidence, usually not very helpful. The next kind of evidence focuses more directly on causation than the first kind of evidence. But unfortunately, it focuses on what philosophers call cause of effect as opposed to effect of a cause. Now, what do I mean by that? The Bryant study is an interesting example of cause of effect kind of research. I'll call it the Bryant study because he was the lead researcher. What he did is he looked at 110 prisoners, 55 who committed violent crimes and 55 who committed nonviolent crimes. And it turned out that 78% of the violent offenders had FLD, or frontal lobe damage, and I'll use that as an example throughout a lot of this talk. And only 28% of the nonviolent offenders had FLD. Well, that's very exciting. The defense attorney looks at that and says, whoa, I can use this. If my client has FLD, I can show that my client's FLD caused the violent crime with which he's charged. The problem is this doesn't really help the defense attorney much at all. All it says, all this kind of research shows, is that a lot of violent people have FLD. It does not show how many people with FLD commit violent crimes. And that's what the law is really interested in. Okay? That's the distinction here. Unfortunately, a lot of the research defense attorneys are sided with is precisely this kind of cause and effect research. So for instance, you got defense attorneys presenting evidence that most prisoners in prison for serious crimes have an extra Y chromosome or more testosterone or something else like that. But that research is almost useless. It's cause and effect research. Basically what it does is it uses the measure of interest, which is violence, as an independent variable as opposed to a dependent variable. The problem is there are lots of causes of crime, as we all know. And in these kinds of situations, intent, needs, desires might be causes. This kind of research doesn't really show us any kind of dispositive information, or even really probative information, as to whether or not the neuroaberration caused the crime. The third kind of neuroscience does a much better job of this. It's research that looks at the effect of a cause. And the most useful research of this sort that we have so far is prevalence research. Okay? How prevalent is violent crime among people with FLD as opposed to people who don't have FLD? And some assertions have been made that people with frontal lobe damage are 5 times more likely than people who do not have frontal lobe damage to commit a violent offense. Well, this is even more exciting. It does suggest significant causation, statistically significant causation. But it has to be put in context. Okay, so people with FLD 5 times more likely. What's the base rate for violence among people who don't have FLD? Well, it turns out it's not very high, probably about 2%, which means what? People with FLD, 10% chance of committing a violent crime. Now that's better than nothing. If I'm a defense attorney, I like that. But still, standing in front of a jury and saying, my client has FLD, there's a 10% chance the FLD caused a violent crime, or something like that, isn't stunningly persuasive. It's not extremely useful to the defense attorney. And of course, you also have methodological problems. Most of this research about prevalence focuses on people with very serious FLD. If the defense attorney only has minimal frontal lobe damage, then arguably the research isn't even relevant. Most of the research also defines violence in terms of any assault. If the defendant is charged with murder, maybe this research, once again, isn't all that relevant to his particular situation. What if we did have prevalence data that showed very high prevalence of a particular neuroaberration in crime? And there is such an example. Many of you are familiar with the Caspi study, which followed a cohort of people until about the age of 26. And what Caspi found is the group that had low serotonin, essentially a variant of the MAOA enzyme, and significant child abuse during their childhood, had an 85% chance of committing a violent act by the age of 26. Now that's a very exciting finding. It's very rare you would get 85% of the variance explained by just 2 variables, child maltreatment and low serotonin. So again, this is very exciting. It seems to be pretty significant proof of causation. And I think this would be very helpful to a defense attorney. But unfortunately, the Caspi study also seems to indicate that every one of those people in that cohort that committed a violent act intended to do it and knew it was wrong. So under current legal doctrine, it still doesn't give them much of a defense. And to go to Stephen Morris, who I'm sure all of you know about, he has said over and over and over again that causation is not excuse. Because if causation were excuse, then all crime would be excused, because all crime is caused by something, right? And that's a little bit simplistic, but that's the basic idea, and I think it makes a lot of sense, at least under current doctrine. I think that's accurate, which explains why this third version of neuroscience probably isn't all that helpful either. But there are 2 more to go, okay? And so maybe we'll come up with something. And I think this could be something. One of the problems with the second and third types of neuroscience research is they try to apply data about groups to individuals. And that can be hard to do. It can be hard to translate data about groups to the individual defendant in the courtroom in front of a judge and a jury. This kind of research gets data about the individual defendant. And so one version of this is we subject the defendant to neurological tests, such as what you see up here, the go, no-go test, the stop signal test, and so on. You know, a lot of you know about these kinds of tests to measure cognitive impairment, to measure impulsivity. And then we see where within the spectrum of impulsivity and the spectrum of cognitive impairment the defendant falls. Okay? But hopefully you can already see a couple of problems with this kind of approach. For one thing, all of these tasks require some kind of choice. So it's relatively easy to malinger. And criminal defendants might have a slight incentive to malinger. Okay, so that's one problem. Plus, it's not clear how lab results translate to the criminal context. So those are 2 methodological problems, external validity problems, internal and external validity problems. But let's assume we can overcome those obstacles. We still have to get the baseline, right? If we want to figure out how impaired the defendant is, we got to figure out, okay, how does he compare to other people? Which means we need baseline information, I would argue, for a whole bunch of demographic subgroups based on age, gender, education level, and so on, because probably impulsivity and cognitive impairment do vary based on those kinds of demographic variables. Now, it's not impossible. It can be done. It just takes a whole lot of work to get the relevant averages. And then finally, the normative issue we have to address, of course, is what do we do with the information we get? Do we give exculpatory effect to this neuroscience evidence if the guy's at the 25th percentile, or does he have to be knocked down all the way to the 2nd or 1st percentile before we're willing to give it exculpatory impact or mitigating impact? That gets to the final version of neuroscience evidence, which takes care of a number of these problems. What it tries to do is get neuroscience evidence about the particular defendant and compare it to the same neuroscience evidence about groups of people who we know are eligible for mitigation, specifically juveniles and people with intellectual disability. Based on the Supreme Court's case law and Roper and Atkins, we know they're entitled to mitigation. So perhaps we can compare the person of interest to those people in terms of their impulsivity or cognitive impairment or their other neurological deficits. And this might avoid some of the problems I just talked about, especially if it's based on brain scans and fMRI scans and chemical imbalances. It avoids a malingering problem. It's hard to malinger that kind of stuff. It might be possible, but it's hard to do it. Also, the baselines are easy to establish. We still have to get what the average juvenile's like, and we still have to get what the average person with intellectual disability is like, but that's all we have to do. We don't have to get all those other baselines that I was talking about in terms of the fourth kind of research. And the legal cutoff's already established. Roper and Atkins have already told us that if you're a juvenile or a person with intellectual disability, you get mitigation. Now, not a lot, but at least you avoid the death penalty, and arguably that could translate to some other areas of criminal justice. So basically what I'm suggesting here is what I've called scientific stare decisis. People with the same scientific situation should be treated the same for legal purposes. So if a 30-year-old has the same kind of brain in terms of function, or it looks like a juvenile brain, then should be treated like a juvenile. Okay, that would be the idea behind scientific stare decisis. Now, is that possible? And of course, that's the $64 million question. Can you compare a 30-year-old's brain to a juvenile brain in any meaningful way? I've talked to B.J. Casey about this. Many of you know she's an expert on the juvenile brain. She was very skeptical this could be pulled off. But then we got people like, Kent Keel, who many of you know, and he just a couple of years ago, completed a study that reached this conclusion. Reduced gray matter in the anterior temporal lobes, amygdala, and orbitofrontal cortex was more helpful in predicting arrest than chronological age. If you unpack that, basically what that means is that maybe we can have scientific stare decisis. We look at a person's brain and see if it's like a juvenile's brain in terms of development in those areas. And if that's the case, maybe mitigation is possible. Maybe neuroscience could have something to say about criminal culpability. And on that note, maybe upbeat, I'm not sure, I'm going to end. Thanks.
Questions for Chris. And I would note, it has been noted that it would be good if you didn't have to repeat, if the speakers didn't have to repeat the question.
But I will.
We're trying to get a microphone to make this work, but here in the heart of Silicon Valley, for quirky reasons having to do with this.
Okay, so good. I can mangle the question anybody want to. Yes, go ahead.
So it's unlikely that we get that good fifth kind of evidence, but if we could get it, what does it mean for people in the 18 to 21 group now, as focus of these intermediate courts, or do we put them with a juvenile group? And actually, well, this 21-year-old brain looks like a 30-year-old. This 18-year-old, this 17-year-old brain looks like a 30-year-old. The flip side of that.
Right. Okay, so Emily from Hastings is asking, okay, if we adopt this scientific stare decisis approach, is this going to backfire on defense attorneys and somehow undercut the ability of post-teenager but young adults, their ability to get some kind of exculpation? I mean, obviously, ideally, what I would hope would happen is that eventually brain science, among other things, will convince the courts that anybody up until about 25 is deserving of some mitigation, which will not only take care of your problem, but also help those over 25 who haven't matured neurologically. That would be the ideal world. Now, obviously, it could happen the other way. The courts could toe the line to 18. They're not going to go beyond 18, conceivably. And then there might be that kind of problem. But even then, I think to the extent you can show that the 18 to 25-year-old isn't that much different than the 17-year-old, which might be the case, I think you could still make this kind of argument that I'm making. And by the way, in terms of whether that would happen or not, granted, it may be a pipe dream, but we do have the Graham, Miller, and Jackson cases where the Supreme Court is seeming to recognize that malleability and treatability is relevant in some way to criminal justice, and that youth tend to be more treatable than others, and therefore maybe that should go into the calculus. I think maybe Peggy's going to talk about it. Are you going to talk about that a little bit? Are you going to? Professor Carroll, you're going to?
Well,
yeah.
And I was just going to add to that, that we're starting to see in the legislature an expansion of the age of minority. So we're starting to see juvenile jurisdiction
Okay, so the comment which builds on what I was just saying is that some legislatures are already recognizing that ending everything at 18 doesn't make much sense. Yes.
Do you see any dangers of the prosecution then saying that this is an exceptionally intelligent or well-functioning 17-year-old and therefore we should go for death in these kinds of cases? So taking the evidence and then, the defense is using it, the prosecution.
Right. Now, so that, yeah, and maybe that's also what you were getting at, Emily, that maybe a well-functioning 17-year-old who's way above average, in the 95th percentile, we should kill that person because, after all, they're not really juvenile. They're an adult in disguise. That's the question from Jessica, in Houston. I think it's possible, but the nice thing is the court has declared definitively that Atkins and Roper are categorical. So unless they're willing to reverse precedent, I don't think that's going to happen. But you're right, that could happen. Yeah. I think we should live with the consequences. I think the argument should be this would be one way of approaching things, and then defense attorneys at least have the tools to argue, and my person, however old they are, should have mitigation because of their neurological deficits. Yeah. Mm-hmm.
Paul Catley of University. You looked at one area where criminal justice might be using this kind of evidence, but when we were looking at English cases, we were finding that there was a whole range of other areas, for
Mm-hmm.
instance, in terms of the cause of injury, where neuroscientific evidence was really useful to the
Mm-hmm.
criminal justice system. And also, case of Mohammed Sharif, for example, where it was really useful in working out whether an individual was fit to plead. And there, the fact that he'd got a degenerative brain condition was able to show that an early decision that actually was malingering was wrong.
Yeah, okay, so the question has to do with whether neuroscience can be relevant in other areas of the law. For instance, figuring out the cause of injury, let's say in a tort suit, or figuring out whether someone's fit to stand trial. And I agree completely, neuroscience can be corroborative. I think that generally speaking, it's not going to be more than corroborative. In other words, you are going to have the behavioral manifestations of inability to understand the charges, inability to talk to counsel, or pain and suffering, and in a tort case, and the neuroscience will help corroborate that. I think the most interesting use of neuroscience in the criminal justice system, if I can just twist your question a little bit, is in terms of evaluating risk. I think it's a fascinating area. Ken Keel, among others, is doing some really good work on that, and I happen to think it's going to be more useful there, though maybe scarier there, than in this area that I've been talking about. But that's a whole other talk, another 15 minutes.
13, you only did 13.
Oh, I did. Well, then, shoot. I'm efficient, yes.
So, Jenny Carroll, I wanted to, and I know you said you didn't want to talk about insanity defenses, but I guess
Sure.
I wanted to push back a little bit on some of the early groups of neuroscience that you felt like should not be used or were not useful, to use your words. I mean, in many ways, though, doesn't this help inform that insanity analysis? Is there an aberration that produces a result that causes the defendant to either not understand or not rise to the level of its diminished capacity defense to the same level of mens rea?
Yeah, Jenny Carroll from Alabama making the argument that neuroscience can be more useful to insanity cases than I'm suggesting. I agree. I think especially with the volitional prong of the insanity defense, it can be very useful. In terms of the cognitive prong, it depends on how the jurisdiction is going to define the defense. If you talk about a lack of appreciation, you have some behavioral evidence the person's cognitively impaired, then it might corroborate in the same way it would corroborate lack of fitness for trial or pain and suffering in a tort case. Most jurisdictions define it so narrowly, in my experience, that it's probably not going to be very helpful. But it is conceivable that it could be. So yeah, I can back off on that a little bit. Like I said, I'm ambivalent about this. Sometimes I think neuroscience will change everything. And one way it might change it, by the way, is by reorienting us away from this whole culpability analysis that we seem to be obsessed with in the criminal system and move more towards a preventive kind of regime, which is scary to a lot of people, but something worth thinking about. Yeah.
Last
Jane?
question.
Jane?
Jane
Yeah.
Moyer from Japan. One of the areas I think I want to follow up with what Jenny said in insanity is the jury's disbelief that the defendant's insane. There's a really robust area of research now on looking at schizophrenia and trying to capture with neuroimaging when people are hearing voices. And so it seems to me that once this type of neuroimaging is sufficiently robust, that it would go a long way to helping dispel a lot of the mythic beliefs that jurors have about insanity.
Yeah,
listened to an article
yeah, a good point.
on seeing voices about this, but
Yeah.
I really think one of the big problems with insanity
Yeah. No, I think that's a very good example. I mean, typically what neuroscience is used for in an insanity case is just to corroborate behavioral impairments that psychiatrists and psychologists have already discovered. So it doesn't do much more than corroborate. It might help, even in that sense. But yeah, the specific example you gave, where if you can show there are neurological manifestations of hearing voices, that would be extremely helpful, because you're right, that allegation usually is disbelieved by a jury. In the Clark case that got away up to the Supreme Court, it's pretty clear to my mind that he was hearing voices. I don't know why I think that. I just think, probably he was. But if we had neuroscience evidence backing that up, I think he would have been much more likely to win an insanity defense. So absolutely. Thank you very much.
Thank you.
All right. Well, I'm going to argue that neuroscience discoveries present a threat to our practice of holding people responsible and blaming them and punishing them. As I think several presenters have already suggested today, this is, I think, an unpopular view among the more savvy legal scholars and philosophers. But I do still want to explore it a little bit further and to suggest that the sharpest edge of the potential challenge from neuroscience has not yet been fully appreciated. As I think was mentioned yesterday, telling biological stories about why people commit crimes does seem to tend to reduce our impulse to blame them. And to me, that seems appropriate and right and makes sense. But as I'm sure you all know, many legal theorists and many philosophers resist this. And I think more precisely, they say if that's what happens when we hear these stories, that's because we're making a mistake. In making this argument, they often adopt the position known in philosophy as compatibilism, according to which causal and mechanistic and deterministic explanations of human acts are perfectly compatible with blaming them, holding them responsible, and punishing them, at least so long as they have certain cognitive and executive capacities, like the capacity to recognize reasons for action and the capacity to act on those reasons. And since there's no reason why caused and determined and mechanistic creatures can't have those kinds of capacities, even the most dramatic and intoxicating discoveries in neuroscience don't really have to pose any sort of threat to our blaming and punishing practices. And so that's I think, a quick recap of the compatibilist position. I disagree with that view, and so I thought I'd try to explain why. And to do so, I'll focus on what I'll call criminogenic neural influences, things that influence the brain's structures and systems in ways that make a person more likely to engage in crime, things like exposure to lead during childhood, chronic stress, head injuries, as Chris just mentioned, living through abuse, addiction, and lots, as you know, lots and lots of other things like this, things that have these criminogenic neural influences. What I want to emphasize is that this area of research has, I think, started to supply us with the tools for telling vivid, concrete, detailed, realistic stories about what it means to be a caused or a mechanistic creature, and that these stories have a sort of distinctive and important impact on our moral intuitions about whether it's morally appropriate to blame and punish creatures like us. So to get at this, I thought I would take a quick, rough stab at sort of sketching out what such stories might look like, and then a quick, rough stab at trying to bring to life a little bit some of the moral anxieties that I think such stories can bring to life. So I'll start with a really simple hypothetical. I'm a 21-year-old prison inmate, and one day as I'm walking through the crowded prison dining area, another inmate bumps my shoulder with his shoulder, fearing that failing to respond will mark me as an easy target in front of my fellow inmates. I respond by punching him as hard as I can, breaking his nose and his jaw. So normally we'd say without any question that I'm responsible for committing a battery and that I deserve to be blamed and I deserve to be punished for doing so. Still, what if we add a couple more details? As a toddler, I lived in an old, poorly maintained rental unit where I was repeatedly exposed to lead dust. And in addition, living in poverty, I grew up with chronic stress. A parent abused me, caused me concussions. I've struggled with addiction. It is not a happy story, but as I'm sure anyone who's worked with the criminal population knows, this is not really an unrealistic story about someone who finds themselves in prison and battering another prisoner. Not an uncommon story for a violent offender. I've been exposed then to these, what I'm going to call these criminogenic neural influences. One of them in the hypo is lead poisoning. So lead poisoning changes the chemistry and the structure and the function of my brain, damages the neurons and synapses that my brain is made up of, changes the balance of various important protein complexes and neurotransmitters in my brain, disrupts the development and the work of my frontal cortex, anterior cingulate cortex, the hippocampus. And it does these things in ways that are demonstrably criminogenic, knocks down my intelligence and my decision-making capacity, undermines my mood regulation, increases the likelihood of depressive and affective disorders, increases the likelihood that I will be hyperactive, that I will engage in aggressive behavior, that I will engage in antisocial behavior. And of course, all of these things then have a criminogenic influence. They make me more likely to engage in crime over the course of my life. Well, so with that in mind, right, imagine the stories we might tell about me and the offense that I have committed. When I was a toddler, I was crawling around in my parents' apartment. My hands got covered with dust, and the dust contained lead. And when I put those hands in my mouth, as toddlers inevitably do, and used those hands to eat, I ingested lead with every bite of food, every lick of my fingers. And as that lead accumulated in my body, it went to work on my brain. It made my brain write a sort of a chemical broth that warped the development and the functioning of the neurons and synapses that made up my brain, skewed the balances of the neurotransmitters and proteins. It stunted the development of several important neural structures. And as a result, I ended up growing up differently than I would have. I grew up less intelligent, less able to interpret complex situations, less adept at solving problems, more prone to impulsive behavior, antisocial behavior, and aggression. More of these things than I would have had I never crawled and played in that lead as a toddler. And all of this, of course, may have played a critical role in my reaction to being bumped in the prison cafeteria. When I was bumped, I had to assess the meaning of that bump, had to think about what it meant about the actor who bumped me, about what it meant for how I would be perceived by those around me. But in thinking that through, in assessing that, I was working with a sort of unnaturally impaired intelligence. I had to decide how to react. But I brought a sort of unnaturally impaired decision-making ability to that task. My desires and my motivations had been channeled in a different direction than they might naturally have gone, towards impulsive action, antisocial behavior, and aggression. And so it's very likely then that my reaction to being bumped in that prison cafeteria was really quite different from what it would have been had I not, as a toddler, crawled around in that lead dust in my dilapidated apartment. And then, of course, we can add to that there were several other criminogenic neural influences that were at work on me at the same time in this hypothetical I posed to you. I was living with the chronic stress associated with poverty, suffering abuse and head injuries, addicted to drugs. Each of these things demonstrably has the capacity to change the chemistry and structure and function of my brain, each to do so in ways that are criminogenic. So we have to imagine what they can do working together, as they often do in real-life cases, on a developing human brain. Imagine how they shaped my reaction in this hypothetical to being bumped in that cafeteria. Well, okay, so there's a story, and so then what's the significance of that story for moral and criminal responsibility? At one level, maybe it's just another piece of the gradual project of making the case that we are ultimately these caused, mechanistic, determined creatures. But more importantly, I think, these vivid, realistic, detailed stories about how our mechanisms lead to our actions may activate several important moral anxieties about blaming and punishing mechanistic creatures like us. I'm just going to sketch out 3 of those anxieties: fairness anxieties, moral luck anxieties, and what I'll call political genealogy anxieties. So the essence of the fairness anxiety is something like this, right? Criminal conduct, we know, triggers popular fear and resentment. Blaming and punishing me for my criminal conduct is, in some sense, making me the target for that popular fear and resentment. But if CNIs, criminological neural influences, are driving my criminal conduct, those CNIs look, at least in one sense, like the more appropriate targets for that popular reaction, that fear and resentment. Rather than fearing and resenting the prison batterer, it makes more sense to fear and resent the conditions and circumstances that made him a batterer, to hate not him, but the lead dust and the poverty and the abuse that first hurt him and then, working through him, hurt us. If that's right, then blaming and punishing him seems like doubling down on harmful conditions rather than pushing back against them. How about the moral luck anxieties that I flagged before? The essence of the moral luck anxieties might be something like this. Most children are not exposed to CNIs like the environmental lead and parental violence and head injury that I was exposed to in this hypothetical. But we know that some are. That divergence is not due to any feature or choice of the children themselves. Rather, it's a matter of luck. Good luck for some, bad luck for others. A lottery of criminogenic influences. Letting this sort of luck determine who we subject to blame and punishment is troubling. The blame and punishment do cause harm and suffering to the blamed and punished. Harm and suffering ought not to be distributed by lottery if we have a choice in the matter. In fact, it seems cruel and capricious to do it this way, and that, again, then should raise moral anxieties about the practice of blaming and punishing mechanistic creatures like us. The essence of the political genealogy anxiety is something like this, and this is the one I have the most difficulty, I think, bringing to life. We know that the CNIs in my case are not distributed evenly throughout our society. They fall disproportionately on the socially disadvantaged. Lead exposure, chronic stress, abuse, addiction, all significantly more common among the disadvantaged than among the privileged. And so as a result, blaming and punishing those whose conduct is driven and shaped by these sorts of CNIs is going to have a disproportionate impact on the socially disadvantaged. It's also going to channel popular resentment and fear about crime towards the socially disadvantaged and steer it away from the social conditions and institutions involved in the generation of and the distribution of these CNIs. And so that's then going to raise the possibility of an association or an alliance between, on the one hand, the practice of blaming CNI-influenced actors, and on the other hand, support for or acceptance of the social conditions and institutions in which CNIs are distributed disproportionately as they are. And so again, to the extent that such an association or an alliance seems unsavory to us, this would be another reason to experience a sort of moral anxiety about our commitment to our blaming practices. So putting that all together suggests to me something like this. The neurosciences challenge responsibility, or could challenge responsibility, not so much by proving directly that we are mechanistic creatures like robots or supercomputers. That's something we probably already knew anyway, but instead by giving us reasons to resist blaming and punishing if we are indeed such creatures. Seeing how these CNIs work shows us that as we continue to gradually map all the countless mechanical paths that lead human beings to do bad things, we may grow steadily, gradually, increasingly uneasy about the fairness and moral luck problems inherent in blaming and punishing mechanistic creatures like ourselves, and about the political genealogy of our practice of doing so. And this uneasiness may ultimately be so hard to put aside that we will no longer think of it as natural to blame and punish each other after all. And that this then, I guess I'm proposing, I think this is the real challenge that the neurosciences pose to criminal responsibility. Okay, start with Chris.
So you are expressing my point of view, and I think neuroscience is going to change everything. I was talking about during my talk. I wonder, though, with respect to your very last statement there, wouldn't you just bring back all the social discrepancies and unfairness that the current system has? Because who would be subjected to preventive detention or some kind of preventive intervention would probably be people who find it hard to change their behavior, don't have the money to do so, or in other ways can't avoid the risk factors that cause these kinds of problems.
So the question is, even if we adopt my perspective, we won't solve the problem of social discrepancies, disproportionate intervention in the lives of the disadvantaged, something like that. Yeah, well, I suppose that might be right. I'm not sure I can argue that wouldn't happen. I'm not sure we need to think right from the start that those sorts of interventions would necessarily be seen as adverse, harmful, or unwanted. It might be possible that we can imagine or come up with interventions that aren't experienced that way. But I do understand that, of course, we've been worried about the possibility of the sort of medicalized handling of crime for decades, and worried that it really does result in paternalistic and destructive behaviors. I guess, you know, the other thing that I guess doesn't show up then in that last sentence on the screen is that, of course, what someone looking at this from my perspective really wishes is that you know, we take into account what we're learning from the neurosciences, not to develop interventions after the fact, right, but to develop policies and arrangements that make crime less likely up front, and that presumably would not lead to the same sort of problem. Yes?
Yeah, Glenn Cohen. So the whole thing has kind of a Peter Strawson second-person flavor of like resentment and what, you know, but it's not clear to me that there's an easy or a necessary move from that to kind of the third-person objective kind of system design. So can you speak a little bit to that?
Well, I think I can speak to it, but I want to make sure I understand. So you're suggesting, I'm suggesting a shift to a third-person objective approach?
No, more that basically everything you said streams right to me. The question is, should I resent someone, or should I, as a second person, have a feeling of blame towards them? That doesn't necessarily answer the question of a system design perspective.
Well, okay. So if I understand the question, I think the sort of first part of my response is, I do think my arguments are arguments that as we continue to move in this direction, those experiences of resentment will dissolve away, and that fuel for our blaming and punishing practices will dissipate. So far, so good?
Sure.
Okay, and then what's the question that follows from that?
Just to say that, you know, you've given me a reason why I shouldn't resent the wrongdoer to me, right? A reason to nullify an ordinary feeling of resentment from a philosophical perspective.
Mm-hmm.
But it's not clear to me that just by doing that, you necessarily said we ought to change the practice of criminal law.
Sure. I mean, there's all sorts of reasons why we might just keep right on doing what we're doing, even if we don't feel that sort of visceral core resentment towards an offender. I certainly think that's true. And of course, you know, you might well say, well, okay, we don't have a retributive justification for doing all of this, but we still have utilitarian justifications for doing all of this. Though, you know, I think if you make that shift, that presumably will ultimately lead to some changes in the ways in which we approach punishment and handling of crime, right? We won't any longer be able to engage in sort of just destruction for the sake of destruction with respect to the offender. I apologize if I'm still missing sort of part of the question, but one more question, I think.
Last question.
Mm-hmm.
I think this is a really interesting, pulling out the moral anxieties is what's doing the work when we're all so focused on criminal responsibility. But I wonder about, I think this is somewhat related to Glenn's question. idea that the CNIs themselves are a more appropriate target for fear and resentment. If it's always, the political reality is it's always the privileged who are making the rules. And we all, as humans, suffer from the cognitive bias of situational, sort of attributing to our own bad things, situational. So you can see it's possible for people to fear and resent situational or structural factors, usually when it affects their own life negatively. But the privileged and elite are not suffering from that problem. But we also attribute to other people the bad acts to them rather than to their situation. So it's harder for the privileged and elite to fear and resent the CNI, the criminogenic factors. To what extent do moral anxieties impinge on cognitive biases and how people evaluate how the rules should change in the world?
So to what extent do moral anxieties...
Moral anxieties you talk about, even if they're there, how do they intersect? How might they intersect with the cognitive biases, the attributional biases?
So is one of the questions something along the lines then of, is there any way this is really going to change, given both that the privileged have no reason to change, and given also that we may all carry cognitive biases that make us unable to sort of shift focus that way?
Yeah.
Sure, I mean, I think those are, great questions. I myself am not yet I've not yet given up on the possibility of change in these areas. I do think with respect to those cognitive biases, I do wonder to what extent those ultimately might be seen as politically generated, ideologically generated, a product of our political culture, rather than of any sort of hard wiring that requires us to live with them. If they were a product of political culture, then presumably a shift in political culture would shift those biases as well. As for the privileged not having an incentive or not having a sort of a visceral reason to shift their perspective, I would just say it's not clear to me why they don't, given that their current approach really isn't working very well in dealing with their own problem when they are faced with a criminal act or a violent act against them. They might ultimately be better off if they were willing to shift focus and to commit to a more sort of systemic approach to crime prevention than to wait until crime happens and then bring the hammer down on the criminal, I guess.
Thank you, Andrew.
Sure.
Well, I thought that I'd take the opportunity to talk to you about a rare experience I've had over the last 18 months, which is of working closely with a neuroscientist, Patrick Haggard of Institute of Cognitive Neuroscience at University College London. And we were asked, in a sense, to work together by the Arts and Humanities Research Council. We put together a bid, which was actually relating to insanity, with a number of other people, and then we were told that if we would like to develop our bid, they might well be interested. So we took the opportunity and we did that. And we decided that before we actually submitted the bid, we'd think about what we could work on together. And why we came up with a sense of agency is that was something that Patrick and I both felt had overlaps between law and neuroscience. So in England, as I will actually show you in a minute, we have something called the Voluntary Act Requirement. And Patrick has a notion of action, which includes both the intention to act, and then the sense of agency comes when somebody sees the outcome of their action and has a relationship to that action in the sense that I caused that. So that's where we started. So a long, long time ago, I did a PhD. And this is sort of was very lucky for me, because it brought me right in where I started. So we started off by discussing the things that had interested me when I was doing my PhD, and luckily I found Patrick was interested in exactly the same things. So we were looking at attributing responsibility, and Patrick was interested, as well as I am, in why we have this moral sense that we're responsible for our actions looked at from a cognitive neuroscience point of view. We will get there. Okay, so if we go all the way back in English law, we have Blackstone. And this is a very Aristotelian view of why we have a sense of responsibility. And here it's all to do with the will and choosing and whether an action is blameworthy or praiseworthy. And really, you can still see that in our criminal law cases. And just to show you that, coming through into the 1950s, we have heart and the sort of liberal conceptions of why we should punish people. And again, this idea that we punish people who have normal capacities, physical and mental, for doing what the law requires and abstaining from doing what the law forbids. And the fair opportunity to exercise those sanctions, those capacities. Now, I don't think we really have a handle on what capacity means. We also have interesting abilities through cognitive neuroscience to look at reflex action and coercion, which we did. But there is still this moral question. Why should we punish people if they have no real choice? So, the project looks at when an act is not voluntary, or when there's a report that it's not voluntary, or where responsibility for the action is lessened where the defendant has lost control. This was specifically because in English law there was a new loss of control defence which rested in part on the idea of fear being a triggering condition. That defence is only a defence to murder, and it particularly came out the way it was because of a number of cases where women killed their abusive partners and were unable to get a partial defence because although they claimed to be fearful, their reaction came late. And we used to have the old provocation defence where your reaction had to be of the moment, if you like. And so if you stayed and waited and took your opportunity later when it was likely to be successful, this was seen as evidence of premeditation. So we were kind of looking around that. I hate to say that, but we didn't get very far with a loss of control defence, and we want to go on doing research together. Okay, so go back to voluntariness, and our traditional view of voluntariness was given in Bratty in the Attorney General for Northern Ireland, and we've got two bits to it. One of which is a lack of physical control, and the much more problematic side of it is the lack of conscious control over actions. So part of our research is looking at when people actually say they have less responsibility, to try to dig out whether there's anything in what people say. Because one of the assumptions that's been made by the courts, and was actually stated in Bratty, is that the automatism defence, as we call it, is the last refuge of the scoundrel, and nobody could possibly not be responsible in those circumstances. So here we have our present definition from probably our most well-known textbook. And you'll see that we're in a bit of a mess, and that there is a degree of confusion as to whether the law is truly concerned with that Dee was conscious of his actions, whether he willed them or whether they were voluntary. So, Patrick is a neuroscientist. Therefore, you might expect him to have fairly determinist views of things, but he's still interested in morality, in the sense of he's interested in why we have this moral sense. I am not going to show you a slide of all the experiments. I will explain in criminal law terms and layman's terms what we did, briefly. He is everywhere. You can find him on the internet, you can find him on TED Talks. He does this much better than I do. So just very briefly, what we did was we thought hard about what might help us to understand this better. And I wanted to know how people felt about their actions if they had an adverse reaction, because I imagine if you commit a serious crime, you get an adverse reaction. And the other thing I'd like to know, wanted to know was how people felt when they were told what to do. Okay, so very briefly, what Patrick does is he does use a clock, two clocks, and a button. So there are some similarities with Libet here, but it's not the Libet experiment. So we know when people actually press the button. The interesting question is, when do they report pressing the button? And when they report pressing the button is when we assume they are noting their actual action occurred. And then the question is, do they feel responsible for that action? And what Patrick's found over the years is when the button press is perceived by the person to move in time towards the event they cause, there's a greater sense of intention, a greater sense of responsibility. When it moves away, there's less of a sense of intention, less of a sense of responsibility. That's all I'm going to tell you. So if, no, come on. Yeah. So let's go back to our law. We've done these experiments, and you'll see here that English law is moving towards the sense that voluntariness is only about physical control. And they might, well, the courts haven't quite got here, but they might go to a sense of just it's to do with that and nothing else. So, what Patrick's concern is that we're careful about where we go with this information, and that actually it's not free will we're finding, but it's an understanding. So it kind of fits with the last talk to some extent, because it's an understanding of what we're doing which gives us that sense of moral control. What we found is that when people were told what to do, they reported a lower sense of responsibility. We could see that in terms of when they pressed the button and they reported. It moved away from the time it happened. When they just chose to act voluntarily, which is a kind of neutral condition when they can choose when to press the button, then that is the sort of midpoint of our judgments. So, coming back to what the law thinks, I think the law has reached the stage where it's asking, could she help it? Did she have a real choice? And I think here there's an interesting gap between the experiments we can do and what the law is looking for. And in the middle of all this, the Law Commission starts to talk about criminal responsibility. And I expected they were going to tell us that the Voluntary Act requirement would not continue to exist in English law, but they didn't. Now, what's happened since is this will go nowhere. You may be aware of the fact there's an election coming up, and unfortunately, all of this research on insanity and automatism, I suspect, is going to go into the big blue yonder in terms of the Law Commission. And so we've got a Law Commission statement, a thoughtful statement, that there is something somewhere that says that a defence based on lack of capacity for self-control is needed. But I'm not sure what's going to happen next, if I'm honest. So, now I'm just wondering which way. Can I just check that I went the right way there? I think I did. That's not the previous slide, is it? No. Okay. So cognitive. I don't. After spending 18 months with Patrick, I wonder if I do anything intentionally. Broad results. So I said to you, the reports of a stronger sense of agency were noted in self-generated actions, neutral conditions. But the self-report of a lesser sense of agency was noted by conditions where instructions were given in relation to the task or where challenging conditions were experienced during the task. Now, what I want to say is a challenging condition is that the task isn't just simple. So, with apologies to one of the speakers, the neuroscientists decided that they would do a Milgram-type experiment and use coercion, and they used lasers. And they did get it through the ethics committee. So nobody was killed in this experiment. But what they did find is when people were instructed to use a laser to inflict a small amount of harm on other people, then they did report, when they did it themselves, a greater sense of responsibility, but when somebody's standing there and telling them to do it, a lesser responsibility. So we have that as our background. 18 months was nowhere near long enough. We've moved forward a small amount. I just thought you might like to see some of Patrick's thoughts about the reasons why we do things. And I'm not going to read them all, but I've got 2 slides here. He's very interesting in the fact that he is interested in responsibility. And he thinks reasons for our actions are probably relevant here. This is where I have to put my glasses on. He talks about normative elements, which I think is quite interesting for a neuroscientist. And very much like the last speaker, he thinks it's our culture and education that probably causes this ability to decide not to act. You know, Lisa, that's a bad thing to do, don't do it. And he's therefore very much into culture and education, and he thinks that a lot of the reason for our action circuits are to do with learning, and it's how we learn to behave. We're still not sure how memory relates to that, and it would be interesting to know from the law, but it seems from his explanations that it's to do with our base level of functioning of the social brain as well as the cognitive motor brain, and I'm nearly there. And where we've been looking at, in some senses, is the fact that we're going to have to sharpen up what our sense of responsibility is and when we hold people responsible. And one of the reasons for this is going to be this. And I would like to stop there and ask for any questions. Yes, that's Chris.
You said you didn't want to talk about the research, but I'm curious how you assess a person's sense of agency.
Well, I was explaining to you that Patrick's there are a variety of problems with correlating law with small experiments in small groups, and I'm sure you're aware of that. But the whole of Patrick's modus operandi depends around the self-report of when you feel you caused an action to come about.
So the self-report, well, among other things, you found that when a person's told to do something, they have less of a sense of agency than when they're not told.
Yeah.
But that, I'm not sure that says anything about the extent to which people control their actions. It's just, the way I would interpret that finding is when you're told to do something, you feel like the other person's at least partially.
But we weren't looking at why people control their actions. We were looking at why people report a sense of agency, and that's something different.
Okay.
Yeah?
So, I wound up coming in late today because when the alarm went off, I turned it off and rolled over and went back to sleep. And I'd like to think that therefore I'm not morally responsible for my lateness because I was so sleepy when I did this that I didn't really have true agency at that moment. And I suspect that people giggling here have done the same thing in their time. But for me, on a more serious note, it begs the question of where is the moment in time that we're trying to evaluate? We know when somebody does something while drunk that they're not completely in control, so we've moved the moment of time back to when they decided to drink. In my case, moved back to the time when I decided to watch another episode of Star Trek Voyager instead of going to bed on time. But in many ways, doesn't all of this conversation require that we first decide what's the moment in time that we want to evaluate for the moral agency and culpability before we even decide what constitutes the culpability?
Can I kind of, because, you know, having spent all this time with a cognitive neuroscientist, so your question is really, where's the moment in time where we start to evaluate? Well, of course, from this point of view, it's from the button press. You know, that's easy. But you've actually asked me a question I'm really glad you asked me, because the next bit is, what about alcohol and drugs? Because supposing our perception that they change the way we behave isn't true. There are cultures where actually getting drunk leads to quite different results from in our culture. And there's an interesting question about why does that happen then? Is it because we perceive behaving like that when we get drunk as an acceptable way to behave? So we'd actually quite like to do this very basic experiment with people who are drunk and maybe intoxicated in other ways that probably have great fun with it. But, you know. But I'm not making great claims to this. It's a small experiment and it's explaining a little thing. But I think what I'm trying to say is neuroscience can probably tell us some things. And I'm not worried about the fact that it's merely corroborative in crime cases. What it is interesting about is actually how the structures work and whether we are just thinking we act wrong. I think I can take one more, can't I?
Maybe two?
Maybe two. Yes.
Judah Carbone from Minnesota. So I'm curious how this fits with the discussion I think you were starting with on why we feel a need to punish. And in looking at some of the cultural divisions in the U.S., punishment is one of those things that divides people. And I wonder if it fits within two worldviews. A worldview that some things are right and wrong, the individual who violates right and wrong must basically repent. given, and there are still constraints on who you can hurt, but rehabilitation and forgiveness and the betterment of the person become the objective. These radically different worldviews frame our idea of what punishment is about. And I suspect correlate with perhaps testable neurological differences, but I leave that to you.
So June's asking how this relates to punishment in short form.
Yeah.
Well, I think there's probably a third way there as well, which is that, you might well hold people responsible from these findings for what they do, because you might think that they have a sense of having caused them, which after all would make them accept punishment in a much more open and maybe approach it in a different way. So maybe this is more about rehabilitation, but still punishment, than it is about not punishing or not saying people are wrong.
And I think that's our time.
All right, so first of all, I want to thank the sponsors of the event, in particular Hank, for allowing me to come and present here. The paper I'm presenting is The Problem with Inference and Juvenile Defendants. And in order to explain that paper, I think it's helpful to give you all a little bit of a background. So very early on in my career as a public defender, I was assigned to represent a 16-year-old girl named Audrey. Audrey was a sophomore at a local high school, Vashon Island. She'd done very well. And on an unusual sunny day in the Pacific Northwest, Audrey decided to engage in what I think is a time-honored tradition internationally among teenagers. She decided to skip school with 5 of her friends. So they went out to the parking lot where she had parked her father's car, which was a hatchback sports car, what every teenager needs to drive, and they all loaded into the car. Now, the car is significant because the car only had 4 passenger safety belts. So when 5 kids got into that car, there wasn't enough safety belts, so they all made the type of decision that teenagers made. None of them put their safety belts on, except for my client, the driver of the car. Now, the story takes a tragic turn. They're driving down this beautiful sunny country road on Vashon Island. My client, and this is going to date the story, is listening to the latest release from Destiny's Child. She reaches down to change the track on the CD so everybody can sing along to Say My Name one more time. She takes her eyes off the road. The car veers over onto the side. It hits a soft berm. She corrects by turning the steering wheel. The car veers, flips, and everyone in the car except for my client is killed. So I'll spare you the details of what was truly one of the most horrific crime scenes I ever had the misfortune to visit. But by the time I met Audrey, it was about 12 hours after the crime. She'd been released from the hospital with only minor bruises. She'd been released to her parents. And the question that Audrey kept asking was, why had this happened? Now, she wasn't asking spiritually or metaphysically why. She was literally asking the question of why. She wanted to know why, given that she was a great driver. She'd done super well in driver's ed. She'd done so well, in fact, that her driver's ed teacher had told her she didn't need to keep driving with him. She could practice with the adults in her family. She could take her driver's test as soon as she turned 16. She did, in fact, take the driver's test as soon as she turned 16. She passed on her first try, something very unusual in Washington State, apparently. And yet, driving on this beautiful day, she was responsible for killing 5 of her friends. So Audrey was a little unusual for my clients. Washington State requires public defenders to be appointed for any juvenile defendant, regardless of the income of their family. Audrey came from an upper middle class family in a relatively elite area on Vashon Island. Now, for circumstances beyond the scope of this talk, Audrey's parents were convinced by the Washington State defense community that she should keep me as her public defender rather than hire a private counsel. And Audrey's parents were somewhat conflicted by this. And what really tipped the balance, I think, for them was, again, for reasons beyond the scope of this talk, I convinced the prosecutor early on that they should not transfer Audrey's case up to the adult court system, that the juvenile court should retain jurisdiction over what was, quadruple homicide with 5 dead teenagers. So that swayed Audrey's parents to continue to retain me. And I convinced them to take the money that they would have spent on a defense attorney and give it to me so that I could hire 3 experts. Now, if we weren't talking about 5 dead teenagers, this might actually be the opening to a joke, right? I hired a physicist, accident reconstructionist.
I hired a driving instructor who my juvenile clients told me was the toughest, meanest driving instructor in all of Washington State. And I hired a neurobiologist from Yale University. So the first expert, the physicist, went out to the driving scene, or to the scene of the accident, rather. He looked at the photographs, and he told me 3 things which were interesting with regard to my analysis of the case. First, he told me that my client was likely driving 70 miles per hour when the accident occurred. That was twice the posted speed limit of 35 miles per hour. Second, he told me that she had turned the steering wheel so hard when she tried to pull the car back onto the road that it had caused the car to do what my high school friends would have called a donut. Washington State, they called it a spin out. And it had caused the car to actually go over on the berm on the other side of the road. That's what caused the car to flip and eject the passengers. And the third thing he told me was that as a result of all of this, my client should plead guilty as charged. She should not go to trial. I took these findings to the driving instructor. The driving instructor did not dispute that Audrey was likely going twice the legal speeding limit, nor did he dispute that turning the wheel as hard as she had would have caused the car to react in the way the physicist had informed me. What he disagreed with was that she should plead guilty. What the driving instructor told me was that it was unlikely that prior to this incident that Audrey had ever gone 70 miles per hour. He pointed out that at the time, highway driving was not a component of Washington State's driver's test, so she wouldn't have been tested on this. In addition, the legal speed limit for highways in Washington State at the time was 65 miles per hour. So Audrey, who always drove with adults prior to getting her driver's license, as required under Washington State law, was unlikely to ever have reached 70 miles per hour herself. In addition, he said it was unlikely that she would have ever tested turning the steering wheel that hard or been in that type of a crisis situation that she found herself on that particular day. As a result, he said she should not plead guilty because she had done what any ordinary 16-year-old driver would have done. And this was a tragic accident, yes, but it wasn't a crime. So this brought me to my neurobiologist. And this is where it gets really interesting to everyone in the room, I hope. So if it's not already. So my neurobiologist told me that I needed to back the heck up, all right? Not quite in those terms. But basically what she said, and this is a vast oversimplification because of Hank's draconian time limitations, sorry, Hank, was that my client, first of all, had only had her driver's license for 7 days at the time of this accident. So she was an incredibly inexperienced driver. Beyond that, she pointed out that in her interviews with Audrey, she had learned something that I had neglected to find out, which was this was literally the first time Audrey had ever driven without an adult family member in her car. She usually drove with her mother, her father, or her 19-year-old sister in the car. And third, she told me, perhaps most significantly, that as a 16-year-old, Audrey's brain was different than my adult brain. And it led her to different decision-making processes, and it led her to different conclusions about risk and potential harm. So why does this matter in the context of criminal law? Well, Washington State statute, like most criminal statutes, and this was a homicide statute, so like all homicide statutes, contains a mens rea or a mental state requirement. Now, a mental state requirement is criminal law's effort, and Chris, you started on this conversation, it's criminal law's effort to demarcate culpability, to try to figure out who is the most blameworthy. So think of it this way. If you're talking about a homicide statute, everyone who is charged under a homicide statute is accused of taking an act that caused the death of another person. So what mens rea tries to figure out is, well, you killed someone, how bad are you though? Are you someone who acts intentionally, the highest degree of culpability? Or are you someone who acts negligently, accidentally, or somewhere in between? It's the difference between Holmes's stumbled over dog and his kicked dog. So Audrey was charged under Washington State's vehicular homicide statute. That carried a mens rea of recklessness. Recklessness in Washington State was defined as the individual subjectively had understood a risk, a substantial risk of harm, and had disregarded that risk. And then it had an objective component, that a reasonable person in the defendant's position would not have disregarded that risk. Put another way, the state had to prove that Audrey had understood that there was a high risk that her driving would either result in the death of her friends or it would result in substantial bodily injury, and that a reasonable person like Audrey would not have disregarded that risk. So this really got me thinking based on what the neuroscientist had told me. I mean, in many ways, Audrey was nothing like me. I mean, or more accurately, she was nothing like me at the time that I met her. She was a lot like the 16-year-old version of me, except she got better grades and she hadn't been grounded yet by her parents, though the criminal charge changed that, admittedly. So she was like the 16-year-old me in that she made a series of decisions that in retrospect, the adult me could say were very bad decisions. But the 16-year-old me would have said, that's a great idea to skip school, pack all those friends in your car and head to the beach. It's a beautiful day after all. But more importantly, Audrey was nothing like the fact finder in our case. Now, because we were in juvenile court, we had a judge as our fact finder. The judge was over 60 years old. He was very fond of showing me the pictures of his grandchildren, so I knew where he was in his life. And he wasn't a lot like a 16-year-old girl who had had a driver's license for a mere 7 days. So the challenge in representing Audrey was to try to get the judge to understand the decisions that had led Audrey to the conclusions that it was a good idea to drive in the way that she had. And this is where we really get to the crux of my paper. This creates, in criminal law, what my grandmother would have fondly referred to as a devil of a problem. The problem is that in criminal law, we ask fact finders to adjudge mental states based on something called inference. We ask them to examine a series of facts and make judgments about what those facts mean, what they tell us about what the individual defendant was thinking. Now, I know what you're thinking, because you've all seen Law and Order, I'm assuming, perhaps with the exception of the Brits in the room. I don't know if you get it overseas. But in Law and Order, the one thing we can always count on is eventually someone confesses to the crime. Well, not to dissuade you from watching Law and Order, but to dissuade you. First of all, it's not true. Not everyone confesses to crimes, right? Second of all, we know, and again, this is beyond the scope of the paper, that juvenile confessions are especially unreliable. You can get kids to say just about anything, right? I can get my 12-year-old on the phone right now, and she will tell us just about anything we want her to tell us if we persuade her effectively. But beyond that, confessions very rarely speak in terms of mens rea. They tend to focus on facts. So the kid might confess, I was driving the car. I changed the CD. I took my eyes off the road. I turned the steering wheel. I couldn't believe what happened. But they very rarely say in a confession, I understood there was a substantial risk that my driving would cause the death of my friends, and I disregarded that risk, and a reasonable person would not have disregarded that risk. And if they said that in the confession, we would all question the accuracy of that confession, and rightly so. So confessions are very bad when it comes to mens rea. So we're stuck with facts. We're stuck with the interpretation of facts. And the problem with inference and the job it does, the heavy lift it does in criminal law for us with regard to mens rea, is it assumes that facts are knowable, understandable, and universally interpretable to a specific mens rea. So if I learned that someone brought a gun last night to Hank's party, and I was charged with making a decision of what that person's mens rea was if they used that gun to kill another partygoer, I would consider several facts, right? I would consider who brought the gun? Why did they bring the gun? Did they bring the gun because, Jake, you were so aggressive in your presentation, we all feared you, and we had to act in self-defense? Everyone in the room is nodding, Jake. I don't know what that says about you, right? Or did they bring the gun because they intended to kill Jake regardless of how his presentation went? So again, we would have to weigh those facts and make a decision. And in doing that, we would ask ourselves, what would I do? What would bringing the gun mean to me? And again, it assumes that there is a universal knowable meaning to those facts themselves. But we know with adolescents from the neuroscience that because they engage in a different thought process, that universal knowable adult meaning may not correlate to their own decision-making processes. So here I have to take another pause and demonstrate my psychic abilities that I know what you're thinking. You're thinking what the Supreme Court has talked about in the context of the 8th and the 5th Amendment. We were all kids once, right? Congratulations, you're right. You were all adolescents once. And as adolescents, you all had this type of brain, and you all engaged in these thought processes. So why do I need some additional information to tell me how I thought as a kid? And in fact, I bet if we all had a couple drinks and we went around the room and we asked, did you ever make a really bad decision as an adolescent? You would tell me yes. You might keep me here all day telling me yes, as has happened in the past when I presented on this. But here's the trick, and this is where I really need your help. You likely, while you remember the bad decision, and you may even remember feeling invulnerable that you could not be caught for making the bad decision, you likely don't remember the process that led you to conclude that that bad decision was in fact a good decision, and two, why exactly you thought you wouldn't be the person who was caught. Because I'm here to tell you, as a former juvenile public defender, you're gonna get caught if it's bad enough. That's what happens, you do get caught. So, in conclusion, what do we do as criminal lawyers? I think a couple things. One, I think we need to start talking about neuroscience in the context of juvenile defendants, particularly with the examination of the substantive question of mens rea. So on that point, Chrissy, you and I are at slight odds. I will also say, and I want to offer this caveat before we go to questions, I'm not saying kids are incapable of forming mens rea. I think they are. I think they are capable of making free will decisions, and they are capable of being responsible. I'm also not saying that criminal law has to rewrite its mens rea standard. I am saying, though, if we are going to continue to use inference, you have to take neuroscience into account. And I will stop. Oh, look at that, 1 second to spare. You just had to quack for nothing. All right.
So I want the moderator's privilege to ask the obvious question. What happened to your client?
She was convicted. That was actually the line I cut. We went to trial, and we actually took it all the way up to the Washington State Supreme Court. We lost. She was convicted. And here's what I think is interesting, in terms of talking about punishment. So under Washington State statute, she was eligible to remain in custody for to her age of majority, 21. She was released after 5 weeks. So she was sent to the Juvenile Reform Administration, which is a state-based facility, and they determined she wasn't a threat, that she felt an incredible amount of remorse, and they released her. Now, what was really sad is her parents refused to take her back. And what they decided was that she had ruined their lives on this close community. So her sister, and here it gets even more tragic, and this is part of why I've stayed in touch with this client.
Sorry I asked.
Yes, well, her sister, who was 19 at the time and was enrolled at the University of Washington, dropped out of school to support her younger sister, who, remember, is 16, and became a stripper. That's how she supported her. So if you want to talk about tragic effects that criminal law can have when we start treating accidents as deserving criminal liability, like, I think Audrey is a poster child. Now, Audrey has since graduated from college, but every time I talk to her, this is the psychological damage of this event is still evident. So you are sorry you asked, but that's the story. Chris?
Did you make any law at the appellate level in terms of how to define reasonable person? Were you able to rectify it to the juvenile, the level of 16-year-old juvenile?
We did get the Supreme Court to agree. The case is Graham versus Washington. We did get the Supreme Court to agree that they should take into account, because the reasonable person standard in Washington State required someone in Audrey's position to do an age-based analysis. We also got the Supreme Court to say that we were entitled to present the testimony of the expert witness. The judge had curtailed some of the testimony, so I took the witness on voir dire, so basically allowed them to testify without it being used for the factual determination, and the court ruled that that should have been taken into consideration. They nonetheless found it was harmless error, so the conviction stood. Yeah.
So I found your portraiture of your experts to be incredibly compelling, and I think it actually paints a syllogism that I think may be helpful for kind of resolving some policy issues surrounding this case going forward. So you have one expert tell you that juveniles' brains are different from adult brains. Clearly true, having remembered stuff myself, right? Also, that what your client did was not necessarily what a reasonable person would have done, because she had so lacked in experience at, for example, driving at high speeds, that she was unaware of what the outcome of what her actions were going to be. She was so green driving at high speeds that she essentially didn't know what to do to correct a problem that she had faced. And you had your physics expert tell you that as a result of her actions, she did something that from a mechanical physics perspective, was done with like violence in an extreme fashion. Not that she was violent, but like the action resulted in a violent effect. So I think this paints the syllogism that we should think about crafting policy with respect to juveniles such that they should either should either not be allowed to make decisions that have a physical effect on other human beings, or that to the extent that they are going to do that, that they're going to learn from their errors, they need to be insulated from harm in the community. This seems to go back to an issue to kind of get on a hobby course for a second about driving. There's just so much about this juvenile neuroscience stuff that's not about, you know, raping and murdering, bringing a gun to a party. It's about getting behind the wheel of the car, right? And so, to the extent we're going to take some of these lessons from this case seriously, maybe the outcome of this is less in the criminal mens rea context and more that we need to increase the driving age in states. And I realize that that's an incredibly unpopular view, especially in California, and that changes the kind of dynamics of the way that we've set up cities and you know, think about all of the instances in which teenagers commit an accident that has violent effects on others surrounding them, and I would bet you that over 90% of those have something to do with the car.
Okay, so I'm going to skip summarizing your question. Sorry, Hank. But a couple things. First of all, Jake, after Audrey's case, there actually was a change in the Washington state legislature that mirrors changes in states everywhere, right? Kids are no longer allowed to drive with other kids in the car without an adult present. And I think that is designed to address that. But I would actually push back a little bit on your claim that most of this neuroscience is relevant to driving alone. I think that kids make decisions all the time across the board in criminal cases that are the product of this poor decision-making processes or this underdeveloped decision-making processes. And all I'm saying is we deal with that procedurally in the Eighth Amendment, we deal with it procedurally in the Fifth Amendment, we ignore it as a matter of substantive criminal law. And I think it is relevant to substantive criminal law. That's my pitch with this paper. And I think I'm out of time, Hank. I appreciate the...
Thanks, everyone, for being here. I am going to start my talk by jumping off of my new book, which was published last year, that addresses many of the issues that Jenny just discussed. But I'm going to take it a little further and talk about capacity and also sort of go off of Dove's conversation and talk about the media. So my thesis today here is that interdisciplinary collaborations, Jenny, between legal academics and brain scientists can lead to the responsible use of scientific discoveries for legal reforms that benefit vulnerable populations. Many human beings, not just juveniles, but many human beings are not rational actors with legal capacity all of the time. When I say legal capacity, I am speaking not of some lay definition of agency, but of the legal capacity which is required to give legally binding consent. Okay, so the proposal today is that brain sciences support the notion that legal capacity works less like an on-off switch and more like a dimmer or a strobe. Law often fails to account for developing capacity, diminished capacity, and declining capacity. And what I want to again emphasize is that diminished capacity is often associated with criminal law, but this talk is solely about civil law, so it could apply to all of us here in this room. So legal reformers can use brain sciences to debunk the myth of the capable rational actor, whether she be a teen, a debtor, an elder, or another vulnerable person. And we need to educate each other, other jurists, and the public regarding the science and law of human capacity. Okay, so I want to talk to you about a case that was percolating through while I was working on this book. And it involves the LA Unified School District. It was profiled on NPR. So I'm going to play you, hopefully, some clips of this NPR report. Sorry. Okay, so let me just tell you about this case. Basically, classic situation, high school math teacher, sorry about that, high school math teacher grooms 14-year-old middle schooler and ultimately gets her to consent to anal, oral, and vaginal sex. Also, though, engaged in this behavior with her when she protested. He pled no contest and was to the charges and of statutory rape, among other crimes, and was sentenced to 3 years in prison. Okay, so you would think a no contest plea would resolve this issue fairly quickly. But the LA Unified School District fought the civil case vehemently. And they hired this man, Dr. Dan Katz, to testify that the sexual relationship matured the 8th grader, thus minimizing her damages, and that the trial court permitted discovery of MS's sexual history as relevant to her maturity and capacity. So California's rape shield statute didn't apply. Karen Fauché was the NPR KPCC reporter who first found out about this case, and she was investigating. She called me in Indiana and said, how can this be? How can it be that the guy is going to jail, but the consent is being used against her in the civil trial? So I sent her the manuscript to this book, which was filled with all the reasons why this was all going on, and discussed California case law with her. And here's what happened, and hopefully, I have another clip. Hopefully this has worked. This is Keith Wyatt. This is what Karen Fauché produced as part of her investigation.
Absolutely. And here's what he said about that. Children make decisions all the time, all right? Making a decision to whether or not to cross the street when traffic is coming, that takes a certain level of maturity, all right? And that's a much more dangerous decision than deciding, hey, I want to have sex with my teacher. Again, talking about a child, he was able to successfully argue that LA Unified had no negligence in this case, no knowledge of this situation. Karen Fauché is an investigative reporter with KPCC here in Los Angeles. Karen, thanks so much. Thank you.
Okay, so that was what was going on with this case. And what Karen Fauché did was she really honed in on the point. Did MS have capacity to give legally binding consent, which means that this was all okay? And so I directed her to the Restatement Second of Torts, of course, and which talks about when children give consent. And it basically says if the person consenting is a child, the consent may still be effective if he or she is capable of appreciating the nature, extent, and probable consequences of the conduct consented to, which means that you need to look at how they develop and understand whether or not they can understand. So if we look at the neuroscience evidence of adolescent development, and I won't go into too much detail, but I do want to respond to Jacob, and that is advances in brain functioning come with a winnowing of cells. So we now know, as of 15 years ago about, that there is a massive blooming of gray cell matter and then a winnowing. And this winnowing occurs on a use it or lose it basis. So we do not want to say to them, don't do this behavior, because whatever they're doing is being hardwired, we believe, into their brains. So whether they're having sex with the teacher in the teacher's supply closet, or doing algebra, or practicing the trumpet, that all is being mapped into their brains. So we want them to be having these experiences, but in a padded cell where they don't hurt themselves or other people. All right. At the same time, there's another process going on, and that's myelination. Myelination is the blooming of white cell matter. So as gray cells are being winnowed, the white cells are developing. You can think of white cell matter as an insulation around a chemical electrical connection. It makes the connection more robust, more efficient. Okay, so myelination levels increase into the early 20s. Okay, let's look at not the neuroscience, but the psychosocial evidence. Lawrence Steinberg and Elizabeth Kaufman. They have come up with something called maturity of judgment. Basically, they're saying with respect to responsibility that peer influence peaks at age 14. The age of the young woman, she wants to be cool, a relationship with her math teacher will really cause her status to skyrocket. Okay. Coherent sense of identity does not emerge again until about 18. Temperance. Impulsivity is stable until about 16 when we give teenagers a driver's license, and then restabilizes again at about 19. Improvement in abstract and less egocentric thinking continues until about 17 or 18, and development of future time orientation continues until about 21, 22. So basically, the car rental companies have it right. You don't rent cars to anyone under 25. All right, so I'm giving you stuff that's old news. You could look, and these are just, random pictures of, wonderful people who are doing research on teens and others. And as researchers uncover new data, we need to rethink our legal assumptions about the nature of human behavior and capacity. So Adriana Galvan and somebody earlier mentioned B.J. Casey. All of these people are doing incredible work and this is happening all the time. They're coming out with new discoveries about this. So if you look at a book, actually, that was published, our co-author, editor, Oliver Goodenough, in 2006. 10 years ago, we knew, and this is a quote by Abigail Baird, and I take it back to the restatement, second paragraph that I talked to you about earlier. Abigail Baird, a neuropsychologist, says, "It may be physically impossible for adolescents to engage in counterfactual reasoning, and as a result of this are often unable to effectively foresee the possible consequences of their actions." All right, so old news, but we're still not applying it correctly. Look at the LA school district case. All right.
Have the ability to look at their laws to see if they're consistent, and at the very least, make the age of consent rational.
Okay, so what I did in a conclusion in that NPR interview was said, look, we need to change the law in California and make it rational. Right after that, I got emails from several legislative aides saying, we heard the NPR report, we want to change the law in California. So I worked with them, and in July 2015, Governor Jerry Brown signed SB 14, effective January 2016, the same month that my book was published. And because I knew about this ahead of time, I wrote a little postscript in the book saying, we need to put this information out there. We need to make it accessible because we can change the law. To all these naysayers, it can happen. So
Civil Code Section 1708.5.5 prohibits the use of a minor's consent in an action against an adult in a position of authority. This law doesn't go as far as I want it to, but at least it's a start, and it would have definitely helped in MS's case. I'm working now with Indiana to change its laws because there are 12 other states where you see this same problem, including New York, including Indiana, and I can't even get this out of committee in Indiana. Somebody told me, well, some of the legislators are worried about their girlfriends.
How old are they? Yeah.
So, what my next project is, and I'm working with my co-author, Oliver Goodenough, is taking this research and expanding it out. And we're working on a project. It's now gone through peer review with Cambridge University Press. We're cautiously optimistic, but it's called The Myth of Consent. And basically, the idea is that brain sciences contribute to rational and structured approach to protect many other vulnerable persons. Legal capacity is not an on-off switch that flips on at the age of consent and off again with old age. The assumption of legal capacity should be the exception and not the rule, and used as a legal shield and not a sword. Okay, so basically we need a scalpel, not a bludgeon for the law. Okay, thank you. Yeah, Emily.
This is excellent. I'm so glad that you changed that law. But I'm immediately reminded of the Scalia dissent in Roper, focusing on the Hodgson case, the adolescent access to abortion.
I'm glad you asked that.
Concern about trying to create a consistent body of law about teenagers that cuts across different dimensions based on a brain science that is actually, and Larry Steinberg can explain that. Like that type of decision making is really different than the type of impulsive adolescent decision making you think you get.
And
I don't think we know.
I deal with that in this book. And so Emily's asking about, if we negate capacity, what about the abortion decision? I deal with that in this book, and the answer is, it's called what I coined legal assent. It means you are able to give legally binding consent, but there is no presumption of capacity. And if the decision is ever challenged, say by the teacher that you had sex with, then the judge would look to see if the original decision was in the minor's best interest. So treatment for medical issues, for drug rehab, et cetera, that's all in the minor's best interest. And so an abrogation, consent stands. And so it really goes back to, but that only happens if there is a challenge. And if the original decision was not in the minor's best interest, then the consent is barred from discussion at any future trial, so that the perpetrators can't use the minor's consent against them. And I'm looking at ways of taking that and expanding it for elders to say, you have some capacity, but not full legal capacity. So how can we use legal assent to help you to use as a shield, not as a sword? Let me go to Kimberly.
So I worry a little bit, most of my work is about reproductive justice, and so I have a very similar set of concerns about particularly young women, like young people in general. I guess there's sort of two thoughts that I have about that. One is that a lot of the decision making that gets made in the context of, say, abortion or access to contraception is not someone sort of sitting alone in a room, right? I mean, you have to actually go somewhere and talk to someone and have conversations. So there's this way in which that is, there's a level of interaction that's captured there. That's a little different, right?
Right.
So they're not those sort of impulsive decisions. But I also worry about the idea of not allowing young people to have agency, right? I mean, there are lots of contexts in which, in part because young people mature at different ages, they have different life experiences. So how do you capture that?
Okay, so the question is, how do we allow for agency, but also help minors navigate? And the answer is we have to give them agency because they need that for their brains to develop, as they need to. And so the way to do that is by allowing them to make legal decisions, but allowing them, and this goes back to basic contract law. Contracts are voidable by the minor. That was a good idea. And so I just incorporate that wholesale and say a minor's consent is revocable by the minor, and adults keep it zipped. And so that way, if there's a problem with the revocation, the judge then looks at the best interest. And I have 1 more minute, so I will go over here.
Thanks. Canada has just legalized voluntary euthanasia, and we're in the process of trying to figure out whether mature minors, with the terminology mature minors, should be able to have access. So I'm wondering what your answer to that would be.
Wow. I want to think about that, but if I'm going to give them capacity, the problem is that what if they revoke, they can't. It's so final. And so what I would say is that, and I want to think about this a little more, so please don't hold me to this, but I would cause them to wait. It's not you never can do it, it's just you can't do it right now. And that could be problematic because they could be suffering, there could be, and I am mindful of that. So there may be a way, if you've consulted with several doctors. But what we also heard yesterday is that these capacity evaluations are highly flawed. And so we need to develop better mechanisms for evaluating capacity. I don't think it's actually possible because we not only have cognitive capacity, but we have volitional capacity. And one of the things we're going to be looking at in our next book is the problems with volitional capacity, and things I'm calling volitional fatigue, volitional preemption. Getting back to Jessica's point about the long agreement that you sign with in vitro fertilization and the buried in the middle of it, I would call that some type of volitional constraint. You can't get from point A to point B unless you sign that agreement. And so is it truly voluntary that you give away all your DNA information, et cetera, et cetera? I don't think so. Thank you.